Are you ready? You are. Great. Okay. Let's get on the record. One thing. There we go. This is 2021CV356515. It's Baldwin County versus State DBHDD, and Ms. Fitzgerald is the head of said agency. We are here to work through the state's motion to dismiss and plaintiff's motion to enforce an alleged settlement agreement. Why don't we start with Baldwin County? Who is here representing Baldwin County?
Good afternoon, Your Honor. My name is Andy Welch. Brandon Palmer and I are here representing Baldwin County, along with the county attorney, Mr. David McCree, is behind us. The chairman of the commission, Mr. Henry Craig, is also here today, and our intern and young associate to be Mr. Chris Webb.
Excellent. You got a full host. I should have said this before we got started. In terms of masks, in courtroom 8D, as is the case for many courtrooms, masks are optional. If you're in the gallery, masks are discouraged if you're going to be speaking, so that I and the court reporter can hear you. But if you have a need or a desire to have your mask on, you are welcome to do that while you're in the courtroom. I won't ever require one to come off. It's just hard to hear the advocates if they are wearing masks. So, Mr. Welch, will you be primarily doing the talking, or you and Mr. Palmer are dividing it up by issues?
We're divide and conquer approach.
Great. Works for me. All right. And on behalf of the state?
Your Honor, my name is Jonathan Lagle. I'm with the Attorney General's office. I represent both the defendants in this case. And with me is Brooke Hines-Chapman.
Great.
Our attorney from our office.
Mr. Lagle, will you be doing most of the talking?
Yes, sir. I will be doing hopefully all of the talking.
All right. Got it. Well, if you fall out, we know you've got someone here.
I have excellent assistance.
All right. Excellent. So let me frame the issue as best I understand it, so you don't have to replow. If I'm right, you don't have to replow what I've got right. I'll promise that. We may learn during the course of this, I've learned in reviewing the pleadings, over 100 years ago, there were fire services provided at Central State Hospital in Milledgeville. But more recently, DHR, before it became DBHDD, entered into a long-term contract with Baldwin County to have the county provide fire protection and first responder services. You don't have to stay standing. You're welcome to. On property that is Central State Hospital. Fast forward, DHR becomes DBHDD, and Ms. Fitzgerald a couple years ago and a month said, county, we're done. We're getting out of this contract. We don't need it. It's expensive. It's not necessary. I mean, the reasons are whatever they were, but we, the state, or we DBHDD, are terminating this agreement. We're not going to be paying Baldwin County anymore to provide these first responder fire services. The county responded by saying, you can't, well, I think the basis was budget reduction is why we're doing it. We don't have money to do it. The county has said you can't terminate for that reason. There may be proper bases to terminate, maybe bad fire services, but that wasn't the ground. It wasn't that your fire trucks keep running out of gas and don't make it to the fire where they have gasoline in the hoses instead of water. That's not the basis for the termination. It was, we can't afford to pay this anymore, and it was expensive. Can't do it anymore. And in fact, DBHDD hasn't paid now for it. In 5 days, it'll be 2 years that they haven't been paying. So there's a lawsuit filed by the county seeking to collect damages for breach, specific performance, enjoining DBHDD from preventing the county from using this space, a few other forms of relief. To that complaint, the state has filed a motion to dismiss. A lot of it has to do with there are a number of different reasons. Mr. Legel is going to cover them. Some of them are sovereign immunity, which I've been dealing with a lot recently. So it pained me to see that phrase, but we'll work through that. So we've got a motion to dismiss that we need to hear today. We also have a motion from the county saying, hey, we worked this out and we want the state to do what it committed to do in the negotiations we had. And it was the agreement was sufficiently final or agreed to by someone on the state side who could actually bind DBHDD that it ought to be enforced. And I'm happy to handle these in whatever order you all want. I will not be ruling from the bench because one school of thought would be, well, heck, if it's being dismissed, you ought to hear that first, because then I could say dismissed, there's nothing to enforce. But this is too complicated for me to rule from the bench. I will need to retreat and read about the many cases that have been cited and think through the sophisticated arguments that have been made on both sides. This is have been well litigated on paper, and we'll see what you guys do on your feet today. So I don't know if both sides spoke and there's one you want to do first. We'll cover both. We've got now less than 2 hours, but we've got some time.
Your Honor, we haven't spoken, but I would suggest we do take these motions one at a time, and I'd say start with motion to dismiss first, but I certainly would like to hear if there's.
Will that pain you, Mr. Welch, if we start with motion to dismiss?
It would not, but it does seem to me that if the settlement has been reached and the enforcement of it, then there is no point to hear a motion dismissed. But I've already heard the court say that you're not making any rulings from the bench today, so I'll take them in whatever order that Your Honor prefers.
Okay. I mean, I think you're both right. If there's been a settlement, don't need to worry about dismissal. If there's dismissal, there's nothing to settle. But because this is the scope that it is, you guys could surprise me, not in the sense that I'm somehow underestimating your abilities. You could surprise me and something is so crystal clear that I do rule from the bench. But if it were that crystal clear, I guess we wouldn't be here anyway. So let's start with dismissal. And then I will hear you out on the enforcement of the settlement agreement. Okay. When you're ready, Mr. Lake.
Thank you, Your Honor. Your Honor, thank you for the opportunity to be heard on both these motions. I don't want to waste the court's time, so I've done my best effort to try to summarize both these motions, but particularly the motion to dismiss, into one sentence. And I would say that we're here because Baldwin County alleges the existence of two contracts, but in the particulars of the motion to dismiss, a contract which the Department of Behavioral Health and its commissioners are legally void. In case of the motion to enforce, don't exist at all. The defendants assert that both these claims should be dismissed. And it does sound as if the court's pretty familiar with the history of Central State Hospital and the history of the formation of this contract. So I'm happy to be as brief as I can, but also allow myself to answer any questions that may come up.
Check it out.
I'm very sorry if that was my pocket.
I don't know. It might have been because it sounded like it was Siri responding to your request for the San Jose Hospital.
Something like that.
Which would really confuse things.
Yeah.
Quiet, Siri.
Yep. Exactly. Your Honor, Central State Hospital is located in the city of Milledgeville, Georgia, and it has been for 170 odd years. It opened its doors in 1842. And over the course of that time, it has encompassed 2,000 acres. And while it has a fascinating history, I'm not going to regale the court in my limited knowledge of it. I do know that with that 2,000 acres, Central State has traditionally been essentially a small city. It has its own steam plants. It has its own housing. It has its own electrical grid.
Is it state-owned property within the city of Milledgeville?
Yes,
or
sir.
It is a long lease?
It is state-owned property within the city of Milledgeville.
So it's a state campus, a large state campus. And historically, it has been almost self-sufficient.
That's correct. And part of that self-sufficiency involves, historically, it has provided its own fire services. In 1999, Central State Hospital has passed through the custodial hands of a number of agencies in the state of Georgia while remaining owned by the state of Georgia. In 1999, the first relevant point for purposes of this discussion, it was under the custody of the Georgia Department of Human Resources. that agency entered into an intergovernmental agreement with Baldwin County in 1999 for fire protection and first responder services.
So in December of 1998, if I was at Central State Hospital and there was a shrub on fire, I'm walking down one of the streets there, and I pull a fire alarm, who shows up?
At that time, it is the Central State Hospital Fire Department.
Okay, state-owned, operated staff.
Well, yeah, state employees, yes.
Okay,
Okay,
and now it's May 1999. It may have taken a little longer for the IGA to go into effect, but same scenario. Uh-oh, a burning bush. I pull the fire alarm. Now it is Baldwin County Fire Department?
yes, sir.
Okay.
That is correct. This was an IGA. This, by the terms of its agreement, it was in place for 50 years, which is the limits of the IGA. And it essentially said that in exchange for Baldwin County providing these fire services and first responder services, the Department of Human Resources would pay approximately $550,000 per year in quarterly installments that would increase over time for the services as they're provided.
And it would increase just because of cost of living, inflation, and there was some agreement as to how it would index up.
That's correct, Your Honor, and that's in the IGA.
Hmm.
Fast forward approximately 10 years, in 2009, the General Assembly dissolved the Department of Human Resources and replaced it with not just DBHDD, but a number of different entities. Those entities included the Department of Community Health, the Department of Human Services, the Department of Public Health, and the newly created Department of Behavioral Health.
Okay, so DHR to DBHDD was not a one-to-one. DHR, there's sort of a diaspora of responsibilities to other agencies, either that already existed or that were created and assumed some of DHR's role.
That's correct, Your Honor. That's an accurate assessment of it. As part of that diaspora of responsibilities and authorities, fire service over Central State Hospital and other places was passed from the Department of Human Resources to the Department of Community Health, and then later the Department of Public Health. At no point has the legislature ever passed authority for Central State Hospital's fire protection to the Department of Behavioral Health.
So it went first to Department of Public Health?
It went to first to the Department of Community Health
Community
in
Health.
2009, and then in 2012, it went to the Department of Behavioral Health, or Department of Public Health.
Did Department of Community Health disappear, or it still exists? It just, for whatever reason, fire services responsibilities had to go somewhere because DHR disappeared, and it went initially to Department of Community Health. Fast forward a few years, then it's Department of Public Health.
That's correct.
Where it resides now.
That's correct.
Okay.
Okay.
All right.
I can, and that's cited in authority in 25(3)(6).
I'm not doubting you. I'm just, it's almost like we're suing the wrong agency then, but hence your point.
Let me move this along and
Okay.
I'll try to help explain that a little more. As I think the court's aware, but there are really three important factors in this summary. One is that DHR was authorized to provide fire services at the time this IGA was entered into. Two, Baldwin County entered into this relationship with DHR to provide fire services at Central State Campus. And three, that at no point has DBHDD ever had authority to provide fire services at Central State Campus.
What about elsewhere? And does that matter?
I would argue it doesn't matter, but to my knowledge, Your Honor, DBHDD is not in the business of fire protection. They don't provide it anywhere within the state of Georgia. With those facts in mind, though, I think it's just go directly to the law, and I can demonstrate why this motion for summary judgment is right for dismissal.
Okay, I'll get you there in a minute, but why the complaint is. If just trying to remember, so Central State was responsibility for operating Central State did go to DBHDD when DHR was dissolved. So that's our connection, is that Central State, which was part of DHR's large portfolio, that went to DBHDD. Fire services did not.
To be
or it's more complicated?
It's unfortunately it's more
Okay.
complicated. I'd like to try to narrow it down and make it easy. There are sections within the code that I don't know off the top of my head, but I'll be able to cite. Give me a second, I can look them up, which indicate the services of Department of Human Resources that went to DBHDD. They include addiction services and a few other code
Bless you.
sections to indicate that.
And you don't, I'm sure you could steer me right to it, but then I'm thinking about it the wrong way. It's not that the legislation said DBHDD, you get central state. It's that you have certain responsibilities, and the operation of central state, or at least the services provided there, some or all, would be services for which DBHDD is responsible.
That's a correct assessment, Your Honor. Yeah,
Okay.
the services include, and to buttress what you said, they include things like addiction services, mental health services, things like that. Those are the services that DBHDD took over from DHR.
Not fire suppression services.
Not fire suppression
Okay.
services, exactly. And in addition to that, the contractual responsibility for contracts held by DHR passed to DBHDD, which is why DBHDD is in this lawsuit.
Okay.
Okay.
So any contract DHR had, regardless of the subject matter, went to DBHDD.
There's a code section. And again, I can find it for the court. I don't know it off the top of my head, but it essentially says that in general terms.
Okay.
What it says in specific terms is the contractual responsibilities. DBHDD takes over contractual responsibilities for the services that DHR provided that passed DBHDD. So again, it relates
that's
to the
different.
services. Yes, sir.
Okay.
Again, it relates to the services such as mental health and addiction services, things like that. There are 3 in the code section.
Okay.
But those are the facts as they existed in 2009. The law is actually hopefully a little easier to explain. As the court's well aware, governments generally cannot enter into contracts longer than 1 year without violating the Constitution's debt clause. They get around this in certain limited circumstances by entering into intergovernmental agreements with other governments. Those are limited but constitutionally approved vehicles by which counties, departments, the state itself can enter into relationships. And those relationships can go for up to 50 years, and they have to be between government entities, but they're also for limited purposes. And those limited purposes are for the joint services, such as activities, services, and facilities, which the contracting parties are authorized by law to undertake or provide. So an IGA is a more limited version of a contract. And there's a case called Mulkey versus Quinlan, in which the Supreme Court explained that, and in a quote, it said that the IGA provision, and I'm quoting, did not empower the legislature to authorize the state and its institutions and subdivisions to enter into any and every contract which they might in their discretion deem advisable. This provision simply means that the state and its agencies and subdivisions may contract with each other with reference to facilities and services theretofore authorized by the Constitution. So if, to paraphrase, if a county or government agency could already perform a service, they can enter into an IGA with another county or organization to perform that service. Your Honor, there have been a number of other Supreme Court cases, which we cited in our brief, which are related to this. One is Nations versus the Downtown Development Authority. In that case, as an example for the court, the city of Atlanta entered into an IGA with a development authority in which one or more of the entities purchased or created bonds. And the city, as part of the IGA, guaranteed 90% of the value of those bonds in the event the development authority didn't essentially recover its own value. The suit was brought claiming that IGA was invalid, and the Supreme Court said, yes, that IGA is invalid because a city can't offer its credit for a period longer than 1 year without violating the debt clause. And this 90% off guarantee was an offer of credit, thereby making the IGA invalid.
But the IGA here seems to be valid at the time it was created because DHR did provide fire services. That was part of their portfolio of services. So as created, as entered, it's a valid IGA.
That is correct, Your Honor.
Based on your description of how IGAs are supposed to work, DBHDD could not enter into that same IGA with Baldwin County because DBHDD does not provide fire services.
That is also
It
correct.
could something about addiction services, mental health services, but not fire services. So isn't the law we want to look at about the transferability, or I don't know what the adjective would be, of the IGA? It seems like it was valid when conceived. Is it extinguished when?
Yes, sir. That's the state's argument.
Okay.
Is that while the IGA may have been valid when conceived, an IGA requires the parties involved to be able to perform the services. And in this case, DBHDD can't perform fire protection and first responder services. Therefore, from the time that the law changed in 2009 and DBHDD was assigned responsibility for the contract, it can't provide the services. Therefore, it's an invalid intergovernmental agreement. I have other cases, which I'm happy to share with the court, but which are also in our brief. And it sounds like the court's got a pretty good grasp of what's going on with regards to that. Let me just share, because I have many words and I'd like to share them.
Okay, share your many words.
Many words. For instance, one case, Your Honor, is Greene County School District versus Greene County. In that case, Greene County sought to purchase a piece of property that was owned by the Greene County School District. In furtherance of that, the two government entities entered into an IGA, in which the county would take ownership of the property and waive its right to recover certain taxes from the tax commissioner in exchange for taking that ownership. The Georgia Supreme Court again looked at this agreement and said, sorry, county, you can't tell the tax commissioner what to do. The tax commissioner is a constitutional officer. You can't, that's outside of your power, and therefore this IGA is invalid. I'll give you a counterpoint case. One is Avery versus the state of Georgia. There have been a couple.
You say counterpoint, meaning this is
one in which the IGA will work.
Okay.
Okay. One in which the IGA will work is Avery versus state. In that case, it had to do with the development of an airport. A county and an airport development authority entered into an IGA to do so. The IGA was under question. The Georgia Supreme Court looked at it and says a county has the ability to develop airports pursuant to a county's powers, and therefore the county could do it. The development authority obviously could do it as well. And so that was a valid IGA. Now, the final case I want to cite is very recent from the Supreme Court, and it's Savage versus State. It's timely because it has to do with the financing of the Brave Stadium. In that case, Cobb County and the Cobb County Redevelopment Authority entered into an IGA to build, finance, and maintain the Brave Stadium in Cobb County. The Supreme Court spent a considerable amount of time looking at the abilities of both of the entities to determine whether they had the power to build a stadium. And as part of the argument, the Supreme Court said, Cobb County, you have the ability to enter into to build, maintain, and manage recreational facilities. The Brave Stadium is a very large version of a recreational facility. Therefore, this is a valid IGA and it's allowed to go forward. In our case, Your Honor, it's important to note that, again, DBHDD does not have that power. They cannot provide fire services, and they do not provide fire services.
What is your response then? One of the rejoinders from Baldwin County is, well, wait, now you're saying it's an invalid IGA state, but this is a new perspective you're offering. And in other pleadings, there was an acknowledgement, passive or active, that the IGA was valid. It wasn't till this motion and this argument that the light bulb went off that, wait, here is an approach that may be legally valid, but I don't know if the impact of not having flagged it years ago or in the initial answer in this case as an invalid agreement is that it's waiver. What's your response to Baldwin's argument in this area?
For purposes of this argument, because it's a motion to dismiss under 12b-6, we're assuming Baldwin County's contention that it's a valid argument. So our original admission and then the amendment to the complaint when we realized it's not a valid agreement shouldn't weigh into the court's decision, because for purposes of this, again, we take all the statements in the pleading is true. But more importantly, Your Honor, to allow the recovery in this case, damages or specific performance, can't be waived simply because, for a variety of reasons, one being sovereign immunity, which I'll address, another being violation of the gratuities clause. The state is constitutionally prohibited from continuing to participate in this contract.
Hence the well, I guess it was decided earlier for different reasons, because there haven't been any payments made under the contract for almost 2 years now.
Correct. And
Okay.
doing so, Your Honor, would violate the I'll get to it, but it will violate the gratuities clause.
Okay.
And so one thing I do want to address real briefly is the provision of fire services in the state of Georgia. It's all captured under Title 25. And generally what it says is there's always someone who is responsible for providing fire services. 25(3-5) explains that under normal circumstances, that someone will be a county. The county will have a county fire department that will provide services. In the case of a municipality that overlays that county, the city is responsible for providing those fire services. Now, the next code section is 25(3-6). That goes back to our earlier discussion about Department of Human Resources Authority. 25(3-6) talks about various state entities that maintain their own authority. And for example, some of those entities include things like the Department of Agriculture, the Department of Natural Resources, the Department of Forestry, and the Department of Defense. Now, traditionally, those state entities have overseen vast swaths of land, and in doing so, they've had their own responses to those sorts of things. In the case of the Department of Defense, for instance, you really don't want the county fire department wandering onto active military bases, so they maintain their own fire department. Department of Human Resources was traditionally, and prior to 2009, included in that list. In 2009, as we discussed, it became the Department of Community Health. At no point has the state agency of DBHDD ever been included in that list. Your Honor, when DBHDD took over this relationship, again, it didn't have authority, and it's not a valid IGA. And this is where I'm going to briefly get into sovereign immunity. As the court's well aware, the state has sovereign immunity, except in situations when that immunity has been waived.
Expressly waived.
Expressly waived. Thank you, Your Honor. The county has asserted that the state or DBHDD has expressly waived that sovereign immunity in this particular case through the ex contractu waiver. And that requires an express written contract between the state and whoever the state is contracting with in order to waive that. Since this isn't a valid contract, it's a void contract because IGAs require both parties to be able to perform the services, there is no waiver for sovereign immunity. So in addition to being a motion to dismiss under 12b6, this is a motion under 12b1. The state's jurisdiction under sovereign immunity.
The waiver plaintiffs rely on, and they have the burden of identifying the waiver and proving that it applies, is the ex contractu waiver. Your response is maybe if there were a contract, but there's not one here because for all the reasons you just gave, the IGA is void or isn't valid because of what you've described.
Yes, Your Honor. That's an accurate assessment of our position, and I don't want to speak for Baldwin County's position on the waiver. But it also, this agreement is void because continuing to pursue it would violate the gratuities clause. And I want to get into that real briefly. As I mentioned when I talked a minute ago about Title 25 and the provision of fire services, someone in the state of Georgia is responsible for providing fire services at Central State Hospital. It might be Baldwin County. Because Central State Hospital is located in the city of Milledgeville, it might be the city of Milledgeville. In fact, pursuant to 25(3-6), it might be the Department of Community Health or the Department of Public Health. Again, it's not DBHDD. But it is a service that is to be provided under statute. And so that service needs to be performed. And any payments in furtherance of a service that is required by law is essentially a gratuity. Pursuing this contract, pursuing any damages or specific performance under this contract would require DBHDD to pay for something that, frankly, Central State Hospital should get for free. And doing so would violate the gratuities clause. And that explains why DBHDD has not and cannot continue payments under this IGA. I want to address a point very briefly. That's the substance of our argument, Your Honor, but I want to address a point very briefly that was raised in Baldwin County's surreply, and that has to do with the impairment clause of the Constitution. I found it to be a fascinating argument, and so I delved into it a little. Baldwin County alleges that this change in the law in 2009 represents a statute that retroactively interferes with the contract, and therefore the statute is allegedly unconstitutional. delving into it, Your Honor, I think this is not an accurate assessment, and I don't think this argument plays out. I don't think the statute is unconstitutional for a number of reasons. First, and to be clear, DBHDD is not attempting to recover payments from 1999 to 2009. It was not a party to the contract. It's also not trying to recover payments from 2009 to when it terminated the contract in 2020. It's simply trying to avoid making further payments on this. That's one. So it's important that when we look at whether a statute is applied retroactively or, in the case of a criminal system, ex post facto, that what that means. And a statute is retroactive, and again, I'm going to quote, in the legal sense, which creates a new obligation or transaction or consideration already passed, or destroys or impairs vested rights. And that's end quote. And it's important to look at that situation as to whether this was a vested right or whether this was a ongoing right, obligation, and contract, an ongoing right for fire services.
What's the difference?
Well, the code discusses it. It discusses two types of contracts in section 13.1.2. It discusses something called an executed contract and an executory contract. An executed contract is one in which all parties thereto have performed all obligations which they originally assumed. Essentially, the contract's done. An easy example would be a real estate transaction in which the deed's passed. An executory contract, which is used more often in bankruptcy, but which applies because it's here, talks about a contract in which something remains to be done by one or more parties. That's the situation that we have here. We still have a number of years of fire protection services addressed in the IGA and a number of years of payments addressed in the IGA. Therefore, it's an executory contract. The test on whether a statute is applied retroactively or not is most recently addressed in the Supreme Court in a case called Polo Golf and Country Club HOA versus Kennard. The cite to that is 306 Georgia 788. And that case discussed the test, and it said to show a violation of the impairment clause, the injured party has to show that a vested right has been affected by the new law. An example.
Oh, and it's not vested because this is an executory, it's an ongoing obligation.
Ongoing obligation.
Not that I bought the real estate and so I have a vested right in it. And now the law has changed and you're comparing that. It is affecting the ongoing business dynamic as defined by a contract.
Yes, sir.
Okay.
That's an accurate assessment. Another example is a recent case by the Supreme Court in 2015 called Borders versus City of Atlanta. This case has to do with a government's pension plan, and these come up a lot, and the impairment clause is addressed in a lot of these pension plans. Employees have been found to have a contractual right to their pension as part of their employment, and over time, the pensioning agency, the government, for instance, in this case, the City of Atlanta, needs to make changes to that pension plan for a variety of reasons. They do so, and the individuals who participated in the pension generally are aggrieved, feel that the pension is now less valuable than it was. They bring claiming a violation of the impairment clause. In Borders versus City of Atlanta and in a variety of these other cases, the court has universally found that a change in a pension plan that only changes future accrual and benefits doesn't violate the impairment clause. But if it were to go back and change past benefits, that's a different story. It's just like this case we have, Your Honor, where that doesn't apply. This only applies to future fire protection and first responder services and future payments. I have another case that is factually very different, but it helped me get my head around this concept too. It's Eag versus Savage. In that case, a child was adopted in 1976. In 1978, Georgia changed its law to say that children, by being adopted, children extinguish their rights to recover on behalf of the estate of their biological parents. After 1978, this child's parent passed away. The child tried to bring a cause of action for wrongful death. And the the Court of Appeals in that case said that cause of action didn't accrue until after the law was passed. It's not a retroactive law. It doesn't impair contracts. It doesn't impair a vested right that the child had. And therefore, it's not retroactive, and it allowed it to continue. Our case is exactly like that. I hope that addresses the possibility of an impairment clause violation, which again, we don't think applies in this case. As the court mentioned at the beginning, there's two other claims in plaintiff's complaint. I want to address them briefly. One's a claim for injunctive relief. And that claim essentially stems from the contract claim. It's a request for preliminary injunction to allow the fire department to continue to provide services and be stationed at the fire station and at Central State Hospital during the pendency of this litigation. And that contract, or that claim is riding under the same ex contractu waiver provision that that count one is riding under. And since I've tried to establish that count one doesn't set forth a successful waiver of that sovereign immunity, we think count two is equally ripe for dismissal.
And is part of what DBHDD is trying to do through stepping back from the IGA is to repurpose the fire station is actually on Central State Hospital.
That is correct, Your Honor.
So it's on it's state property that is being used by Baldwin County to operate. I'm gonna call it a fire station. It may do more than that, but basically, there's a fire station at Central State that is a Baldwin County fire station. If this case is dismissed, if you get the relief you're seeking, one, Baldwin County doesn't get future payments for providing fire services. They won't have recouped what they ought to have been paid if they were correct over the last 2 years. And are the fire trucks and the firemen evicted? Or that's not what's at play here, because Central State is not, or DBHDD is not trying to evict them. They just don't want to have to pay for it because that would be a gratuity.
Well,
or is that not relevant?
The court is by no means wrong, but there's more to it than that. The service, my understanding of the services provided by Baldwin County, in its full candor, are they not only provide fire and first responder services at Central State Hospital, but they do so for the surrounding parts of the county.
That was my understanding as well. Yeah. So that there's a benefit to the county, yes, or at least people who live near Central State, because if they hit 911, the truck may actually come from what I'm going to call your fire station, meaning the one on Central State. So there's that add-on. But I guess my question is, if this is dismissed and the IGA remains void, dissolved, whatever terms we're going to use, what happens to the assets that are located at that fire station?
Well, the real estate assets are owned by the state, and the personal property assets are owned by and operated by Baldwin County, including the employees. They would have the opportunity to take those assets off. We're by no means going to try to, steal their fire trucks.
No, that wasn't my point. I just wasn't sure if one way this sorts out is that Baldwin County was getting money from the state as a result of the IGA. But if the IGA goes away, does Baldwin County then need to pay rent to use that facility, meaning the fire station at Central State? Or has DBHDD said, either in these negotiations or in the answer, I just don't remember if there's been anything, no, we want you out. You have to park those trucks somewhere else, put your defibrillator somewhere else. You can't use, we're not going to pay for it, first of all, but also you can't use that fire station because we're going to sell the land, we're going to use it as a gymnasium, whatever.
Right. As I understand it, Your Honor, and as I do know this for a fact, is that at this current point, we are not seeking the eviction of the Baldwin County Fire Department during the pendency of this lawsuit. And what may happen after the dismissal of this lawsuit, I haven't spoken to my client about that. I don't know.
That's not something that's on the table in the litigation. Maybe in the settlement, that's not my question, but in the back and forth in the litigation, that's not part of it.
That's not that I'm aware of, Your Honor. And not that I'm aware of, Your Honor.
Okay.
But I do want to address also, there's a third claim in plaintiff's complaint. It's in plaintiff's amended complaint, and that claim is for mandamus. Mm-hmm. We also think that claim is ripe for dismissal. First of all, that claim is only tangentially related to the contract that we've been discussing. So we're kind of shift. I'm going to shift gears a little bit. Essentially, for the mandamus claim, Baldwin County is alleging that DBHDD is not maintaining the property, the Central State campus property, as required by the State Property Commission policies. And that since Baldwin County has to perform fire services at Central State, they have brought a mandamus claim to ask DBHDD to pursue those policies of those state property commission policies. Your Honor, we don't feel that this is an appropriate use of the mandamus vehicle, particularly because mandamus has two elements. One is there has to be no other legal remedy available, and the applicant has to have a clear legal right to relief. In this case, we believe Baldwin County doesn't meet either one of those. We begin with the adequate legal remedy. We feel that a declaratory judgment is an adequate legal remedy in this particular situation, because the purpose of the Declaratory Judgment Act is, I'm going to quote, is to settle and afford relief from uncertainty and insecurity with respect to the rights, status, and other legal relations, and it is to be liberally construed and administered. The state Supreme Court has observed that a declaratory judgment action is an available remedy to determine the applicability and, I quote again, enforceability of a statute where an actual controversy exists with respect thereto. And courts construe the Declaratory Judgment Act liberally and merely require the presence of the presence in the declaratory action of a party with an interest in the controversy adverse to that of the petitioner. This is, I've used the word liberal twice. A declaratory judgment action can be brought under liberal circumstances to address questions of law in cases such as this. I would argue that the declaratory judgment action differs from mandamus, which has been regularly reported by the courts as harsh and extraordinary. To be sort of blunt on this, Your Honor, this is, as we've addressed, state-owned property. A declaratory judgment action is appropriate because of the new constitutional amendment that was passed in last year and went into effect in January of 2001, which allows declaratory judgment actions to be brought against the state. In particular, that constitutional amendment is a roadmap. It provides that an aggrieved party can bring a declaratory judgment action in the Superior Court seeking declaratory relief from acts of the state or any agency or officer or employee thereof outside the scope of lawful authority and in violation of the laws. That's essentially what they're seeking here, relief for alleged violation of the state property commission policies. The next element is the element of a clear legal right to relief. This requires an affirmative duty, and again, to quote, that must be clear and well-defined. Mandamus a mandamus can't require an entity to perform broad courses of action and discretionary duties. They have to be what in other circumstances are referred to as ministerial duties, as opposed to ministerial and discretionary differences. The declaratory judgment action is, again, a better solution in this case to the question posed here, because it allows the state to use its discretion in maintaining, securing, and protecting or handling the properties down at Central State Hospital. The state property commission policies don't have the kind of specific ministerial responsibilities that would generally be associated with a ministerial duty and therefore so appropriate for mandamus. They include things like a general course of conduct. They include keeping property up to community aesthetics and things like the prevention of vandalism and vagrancy. To be frank, Your Honor, DBHDD is actually already pursuing a course of conduct similar in furtherance of this. They've committed $5 million to abate, mitigate, and when necessary, demolish or reform buildings on campus. But this $5 million outlay and the extensive work associated with it isn't the type of thing that has a specific ministerial duty that makes mandamus appropriate. It would, if anything, be a declaratory judgment action. As a result, we don't think mandamus is appropriate for both reasons. It's not a clear legal right, and there is an alternative remedy. And at that point, I believe that covers the claims that the state would like to see dismissed here.
Can you say again, the SPC, what's that stand for? This is,
yeah, State Property Commission policies.
okay.
And for the court's clarity, a copy is attached to Baldwin County's response to our amended motion. And we cite to the website, which has the most current situation of those rules.
And that's what Baldwin County is seeking to have Ms. Fitzgerald, is it director? What's her title?
Chief Commissioner.
Commissioner Fitzgerald to uphold or apply. And your point is that's not, that's so discretion. How do you mandate someone to go do, it's not a specific thing. You can, a judge can require a state actor to do a clear thing, consider someone for parole, but not, you must give the person for parole, give them parole. You need to have due process such that they have a parole hearing consistent with your policies, but you can't mandate the parole board then to have a specific outcome.
That is correct, because that
Okay.
specific outcome requires discretion on the part of the parole board. Yeah,
Right.
Your Honor's right.
Okay. All right.
All right. Thank you, Your Honor. Appreciate it.
You are welcome. Thank you for your work on this. So I see Mr. Palmer standing up.
Judge, I do have a notebook with much of the authority that we're relying on, if you would like that.
Sure. Thank you so much.
Yes, sir. Thank you. I'm going to take the points made by the state in order, unless Your Honor would prefer. All right. So the state first argues that the agreement that was entered into in 1999 by the Department of Human Resources and Baldwin County, though the state admits was valid at the time it was entered into, is no longer valid. It's the county's position that the relevant inquiry for this court is, was it valid at the time it was entered into? It's been admitted to. Department of Human Resources had control and custody of the Central State Hospital, and the agreement was valid. That's the end of the inquiry. The rationale is, at the end of the day, we are relying on the constitutional provision, Your Honor, in tab number 7. Which is not just a prohibition against retroactive laws, but also laws impairing the obligation of contract. That constitutional provision was likewise codified in the statute following that constitutional provision in the notebook, OCGA 1-3-5, which says laws prescribe only for the future. They cannot impair the obligation of contracts, nor ordinarily have a retrospective obligation.
But how would that apply in a situation, let's say the legislature passes a bill next year, or I guess it could go into the Constitution, that says no more games of chance at service stations, these things that aren't quite gambling, the digital slot machines, if those are outlawed, but I had a 4-year contract to have one in my store, or better yet, I'm the one who leases those machines. And I had a 4-year contract with 200 different gas stations, and this law passes. It's now illegal to do this stuff. Do I have a claim that you have wrongly impaired my contract, even though the contract would be void going forward because it would be a contract to engage in illegal activity? I'm not suggesting anything illegal here, but by analogy, facts and circumstances change. So if we evaluate the contract day after legislation is passed, it's just not a valid contract anymore. It is impaired in the sense that it's gone, but walk me through that scenario.
So I'd point this court, and it's in the notebook, tab 8, Aycock versus Martin. And this is just showing that this has been a staple in Georgia law going back to the 1800s. And the Georgia Supreme Court said there, the binding force and coercive power of the law applicable to the contract is the same existed at the time it was made, constitutes the obligation of the contract. Goes on to say, any subsequent act of the legislature, therefore, remedial or otherwise, which alters or changes the then existing law, which created and defined that legal obligation to such an extent as to make its legal force and power less binding, postponing or obstructing its enforcement, or just imposing conditions on its performance, not prescribed by the law which created and defined that obligation at the time the contract was made, necessarily impairs it and is prohibited by the Constitution. So I think that there is a problem in this case where the state authorized the Department of Human Resources to enter into this contract. It enters into this contract for 50 years. Then all of a sudden, the General Assembly passes on this authority. And I want to cover this in a second, but just to answer your question, let's assume that they passed the authority to some other department, but they passed this contract on to DBHDD. That is a violation of this constitutional provision. It was the state that entered into the contract. They can't then say,
Well, the violation would be if then DBHDD walks away from the, I mean, they didn't at first, they were paying. Or you're saying it was even error to pass responsibility for this IGA to DBHDD? If that's how this court and the other courts are going to construe how that the authority was passed from DHR to not DBHDD, but this other department. I don't think this court needs to make that determination. I think it's contrary to the express text of the statutes, as well as this court knows, it's bound by the canons of interpretation that it's to interpret contracts and statutes as constitutional where possible. And the General Assembly is presumed to know the status of the law at the time it enacts legislation. It was aware of this constitutional prohibition. I'll refer this court to tab 4, which are the statutes which created the Department of Behavioral Health and Developmental Disabilities. Starting out with OCGA 37-1-2B, this was an express acknowledgement by the General Assembly as to the outstanding leadership and support for mental health on the behalf of counties. They were recognizing that counties have, especially Baldwin County, have done so much toward advancing mental health, and they say that that the General Assembly should ensure that the county governing authorities have an expanded level of input into decision-making and resource allocation, and that any services or programs should continue to use and expand their use of county facilities and resources wherever appropriate and possible. The next statute, 37-1-4, says all of the powers, functions, and duties of the Department of Human Resources as they existed on June 30th, 2009, relating to the Division of Mental Health, Developmental Disabilities, and Addictive Diseases are transferred to DBHDD. I'd argue, Your Honor, that this would include all of the powers that have gone, I mean, we put basically a mini treatise together going back from the 1800s to present, showing that all along, all of these same responsibilities and duties have been passed along to DBHDD. And one of those included the authority to enter into contracts and delegate services, which would have necessarily included fire protection services. And perhaps most material to this case is OCGA 37-1-5, where the rights, privileges, entitlements, and duties of parties to contracts, leases, agreements, and other transactions entered into by DHR, which relate to the functions transferred to Department of Behavioral Health, shall continue to exist. This is the General Assembly acknowledging that the Constitution prohibits them from going and voiding these contracts. They're saying we're not going to void these contracts. Instead, what's going to happen is DBHDD is going to be substituted in and retain all of the rights and responsibilities under the pre-existing contracts. For the functions that were transferred.
Sure.
I guess that's where you're going to need to fill in some of the blanks for me, because this language you read to me tracks, as I understand it, exactly the argument Mr. Legel made, which was DHR blows up or dissolves, and things get pushed in all sorts of directions. This statute, 37-1-5, says, all right, DBHDD, you get from DHR anything and everything within, and it lists their functions.
Yes, sir.
But those aren't, I know it doesn't say anything about fire suppression, but it's clear from this language that it would be the things that DHR did in the space of mental health, addiction, behavioral health, that moved from DHR to DBHDD. Other things that did went elsewhere, and we don't need to worry about those, except if one of those was fire suppression. We need to worry about that because it didn't go to DBHDD. So what in here says, hey, because DHR was mixing here, they were taking care of mental health services and providing fire suppression services in this property, that little piece of fire suppression goes with it. If they also had a nuclear facility there, because DHR used to be responsible for nuclear plants, would that also be DBHDD's responsibility under this interpretation?
So 2 points. Number one is, again, this court has a duty to interpret these statutes in a constitutional manner. And I'd argue the only way to interpret these in a constitutional manner is that the fire protection services contracts, duties, responsibilities were transferred to DBHDD. The other point I'd make is the state has failed to show where, and by statute, these fire protection powers were transferred to any other agency. They've pointed, Your Honor, to OCGA 25-3-6. But if you were to, and I've got a copy for Your Honor, but if you look at what that article is about, it's about local fire department powers. And OCGA 25-3-6 just enumerates some other local and state agencies to say this article granting these powers to these local departments shall not affect the duties, powers, or responsibilities of these other agencies. It does not itself transfer or give any fire protection authority to these agencies. So the only citation to authority in the record is that the duties and responsibilities of DHR were transferred to DBHDD.
Okay.
Your Honor, as to the issue that has just been brought up today, this difference between vested rights and non-vested rights, we'd ask for an opportunity to do a little research and perhaps file a supplemental brief. This is the first time
this was new to you. It's new to me, but I assumed you guys nod your heads. Like, okay, we got that. So this was to you a new argument.
Yes, Judge.
Okay.
However, I would bring up just on the forefront today that I believe that there is a vested right in that the state acts as though this is just a monetary issue, but there's a much bigger issue. This is a fire department that Baldwin County has used not just to provide fire protection services to Central State Hospital, but also some of the citizens and residents of Baldwin County in the unincorporated area. And so
let me ask you about that. I'm sorry to interrupt, but you bring up an important point. If we think about the equities and the goodwill for the community, I don't know that I'm supposed to consider that in some of these legal arguments, but I'm not unaware of them and I'm sensitive to them. Why should DBHDD be paying for fire services that would go to Oak Street that is a half mile outside Central State Hospital? Because that's within the radius of 911 fire call dispatch to Baldwin County Fire Station that is on Central State property. And then they go get the cat out of the tree on Oak Street. Has nothing to do with the state, has nothing to do with DBHDD.
Well, the state is only paying Baldwin County for the fire protection services it provides to Central State Hospital. Part of the agreement is just, we've already got this fire facility that you're going to use to provide fire protection services to Central State Hospital. You can also use it to provide it to these citizens of Baldwin County. Okay,
so Baldwin's not prohibited from dispatching a truck to Oak Street outside the property as long as that doesn't interfere with the services provided within the 2,000 acres.
In fact, it's expressly authorized by the contract.
Okay, didn't realize that. So that's a good benefit for the county, but it's not that the state is, hey, here's another dispatch we need to bill you for. There's this fixed amount. It's more than $550,000 a year now, but that amount contemplated providing services just within the 2,000 acre compound. And if there were an ability for that station to help Milledgeville residents outside, they're free to do that.
Yes, Judge.
Okay.
And in fact, I think that is why, and again, we'd ask for an opportunity to do a little research as to whether there is any issue as to vested right versus non-vested rights. But I think this does create more of a vested right in that it's the use of the property rather than just the receipt of payments. You've got Baldwin County who entered into this contract with the understanding that they'd be able to use this fire station for 50 years. So rather than go and spend county money to build a fire station, now all of a sudden the rug can be pulled out. And where are these fire trucks going to be housed to provide fire protection services to these citizens in the unincorporated area around the campus?
Is it your sense that the rug is going to be pulled out, or is it your sense that there would be a thoughtfully negotiated withdrawal from that facility if the way this litigation plays out is that the IGA is determined to be void?
Well, we can get into the settlement negotiations on the other motion, but without the agreement, if this court finds that the state can just up and void the contract by virtue of a statute, then
there's no guarantee.
Exactly. There's no right. Which is why I think it's got to be interpreted as a vested right. This is not something that is ongoing. This is something that they entered into, and it vests that right in the use of the property.
Okay.
All right. Bottom line on that, just to kind of wrap up, Judge, I think the relevant determination is what has been admitted to by the state. And that is the only applicable question is, was the contract valid at the time it was entered into? That's what the intergovernmental contracts clause of the Constitution says, is you can enter into these contracts. DHR had the authority. It's a valid contract. Just real quick on the sovereign immunity issue. Yes, we have cited to the ex contractu provision, which has been defined by Black's Law Dictionary. Is it a claim arising from or out of the contract? Clearly, our claim for injunctive relief is just asking for a form of specific performance during the pendency of the litigation. So we're asking to be able to continue to use the facilities to provide fire protection services and access to the Central State Hospital campus, which is authorized by the contract. And we've cited to precedent, which is clear that even injunctive relief fits within the ex contractu waiver of sovereign immunity for claims where the substance of it is seeking specific performance.
Okay.
On the writ of mandamus, the writ of mandamus is to compel a due performance. It's where a public official is failing to fulfill a public duty or obligation.
You agree that that claim would apply only to Commissioner Fitzgerald?
Yes,
I think it may have initially been brought against both, but it's only Commissioner, and it may not have been, but it's only Commissioner Fitzgerald that I or any other judge could seek to compel to act in a defined way.
Yes, sir.
Okay, so on that topic, what I'd like you to focus on is how the requested compliance with the State Property Commission policy is non-discretionary. I didn't ask that real well, but it sounds like I haven't read a lot of State Property Commission policies. It says general things like you got to keep it up, you got to make sure this and that, and it's not as specific as you must do it. Every door has to have 2 locks. That's specific. If you point out every door has 1 lock, then I could mandate that type of performance. But if you need to make sure it's a secure environment, well, that's a subjective term, and there's so many different ways you could do that. Armed patrols going on, drones. I mean, lots of different ways you could do it. Walk me through why you think that the SPC 01, whatever it is sufficiently specific that it would be appropriate to require the commissioner to do something with that.
And I've got a copy of SPC 01 in tab number 16, Your Honor.
Excellent.
Okay. All right. So there on the front page, it says the purpose, and I've got highlighted there, custodial agencies are required to keep their buildings in proper condition until either change of custody or conveyance of title to the property. Proper condition applies to not only the physical condition and upkeep of the premises, but specifically requires the utilities, power and water, and HVAC to remain in operation to service the limited needs of the shuttered building. I'm going to go to the specific requirements, but even just in the purpose, that's something specific. HVAC's got to remain operational. And it's clear that it says custodial agencies are required. Go on to the second page, Your Honor, and there's a bifurcation here in the policy between buildings with no or minimal value and buildings with value.
Is that already getting us though into the realm of discretion? Or is that defined somewhere else? I mean, I'm now the commissioner of DBHDD. I'm touring Central State. I've got all sorts of advisors, including, I guess, folks who know something about the value of building. That one, we don't need that building anymore. Why do you say that? Well, our vision for the future, for which we have complete discretion to design, is we're not going to have dormitory housing. That's not conducive to mental wellness. So no more. So that dorm, yeah, we could turn the HVAC back on, but that building is of no or minimal value to us. Swap out commissioners. Oh, we want dorm housing. That building's real important. So even just those two categories, the bifurcation strikes me as being discretion laden.
Well, either way, I think, as you'll see here, I've highlighted the requirements. So no matter if the commissioner or Your Honor determines that building A is a building of value or of minimal value, there are specific requirements laid out in this policy that must be abided by. So subsection B, should the building be determined to have no value greater than the land value, requirements are to have all utilities shut off except for water and power to the extent of preventing detrimental conditions. That's specific. You have to have all utilities shut off except water and power. Periodic landscaping doesn't tell you how often, but it's clear that there's a clear duty that you've got to keep up the landscaping to keep up the appearance and value of this property.
Except that it says requirements could be limited to. That seems to give the decision maker discretion of, yeah, I'm going to limit it to that, not shall be limited to. So if you find already discretionarily that the building has, we'll call it no value, then the requirements could be limited to. So I'll let you, decision maker, decide.
Could be limited to. In other words, perhaps there's discretion to add on additional requirements, but these are clear. These have to be abided by. That's the way I interpret that, Your Honor.
Okay.
Prevention of hazardous conditions such as mold to eliminate the possibility that costly remediation may be required at a later date. Had this policy been abided to, there wouldn't be this need for this remediation at this point. And that's really the point of all this. It's become an environmental hazard to the community. And that's at the heart of this mandamus claim.
Okay. And that, we needed to probe you on that a little bit. The whole reason for this mandamus, I mean, these are connected in the lawsuit because it's Baldwin County and DBHDD, but fire station or not, the community also has a concern because of the conditions, the state of disrepair into which the campus has fallen.
Yes, sir.
Okay.
And just so we're clear, writ of mandamus can be applied for by anyone. Anyone has standing. So you don't have to show any particular standing, if that was what you were getting at.
No, that wasn't what I was getting at. I had linked it in my mind to the fight over the fire station, and they are connected because it's Baldwin County. It's the same lawyers, it's the same lawsuit, but it's a separate issue. It is trying to get the state agency responsible for that property to comply with the state property commission policies.
Yes, Judge.
Okay.
And Mr. Welch makes an excellent point as well, is Baldwin County Fire Station and the fire department has been providing these services. And by these buildings not being kept up, it creates a hazard for those firefighters anytime they have to go into these facilities. If they get a call that there's some trespassers because these buildings haven't been properly secured, they have to go in. I've been in them. There's elevator shafts just empty that anyone could be falling into. You can imagine in the middle of the night.
It sounds like a great movie set for some apocalyptic film that they want to make. And so maybe Georgia being the great film state and all sorts of tax credits, state could do something there. But you don't need to demonstrate standing in my mind. I need to keep separate this mandamus thrust. It may be strategically connected to, hey, let us keep the fire station, but they really are separate, independent of whether the fire station stays or goes. The community has a concern to keep these buildings in line with the SPC.
To put it another way, it doesn't matter whether there's a contract or not. The commissioner has an obligation to keep up this campus and secure the facility to prevent vandalism and or vagrancy. That's a huge one because being on a college campus, these buildings need to be secured to prevent students. I mean, people come and travel to these buildings because they're unsecured to go in and take videos, ghost hunts, that kind of thing. And then C, the departing agency should remove all agency-related documents, files, computer equipment, and furniture, fixtures, and equipment owned by the agency, and that is not affixed to the building. Anything that the tenant agency does not plan to relocate to their new location should either be stored at an alternate site or properly disposed. All litter and garbage should be removed, and the building should be left in broom swept condition. Again, Your Honor, I think that these are all clear. We've cited in our brief as to why the should is to be interpreted as shall in this form.
Okay.
And then no flammable or hazardous materials should remain in the building. Again, I think that's clear, Your Honor.
Cole needs to be quiet. All right.
And then we've got policies for buildings of value, Your Honor. I don't need to go through them unless Your Honor has specific questions. But again, I've highlighted what I think are clear policies. HVAC should be set to protect the building. All lighting should be in the off position. Landscaping should be maintained. Post of listing of contact information for local police and fire departments. And that agency should plan to visit and or inspect the property at a minimum of once per month to ensure the building remains in fair condition and no unexpected damage or trespassing has occurred.
Got it.
Your Honor, I'll rely on the policy, but the only other thing that I did want to address is a declaration does not provide adequate relief. The authority relied on by the state is only where, and I think Mr. Legal said that declaration can be used to test whether a law is constitutional or not. Here, we're not trying to test the validity of a law. We're just saying, Judge, you should enforce this law as written. The commissioner has a clear duty. She's not fulfilling that duty. And so a writ of mandamus is the only adequate form of relief. The 2020 constitutional amendment provides no recourse either. That was adopted after the Lathrop v. Deal decision by the Georgia Supreme Court, in which a petitioner tried to sue Governor Deal for a declaration that a law he was enforcing is unconstitutional and an injunction to enjoin his enforcement of that law. Supreme Court said, you could be entitled to that prospective relief, but you've got to sue him in his individual capacity. What this constitutional amendment says is for that declaration that law is unconstitutional and that injunction to prevent the enforcement of the law, you now, rather than suing officials in their individual capacities, if it's a state actor, you sue the state. If it's a county actor, you sue the county. That's all it does. It doesn't provide any adequate relief under these circumstances. Unless Your Honor has any further questions. You have anything? Your Honor, the only other point on the validity of the contract is if the contract responsibilities are delegated to DBHDD, but the fire protection services go to some other agency, then what is going to happen to that contract? It's just kind of out there in the void. Your Honor, we'd ask that you deny the state's motion to dismiss. We'll rely on our briefs and argument. Thank you.
Thank you. Mr. Legel, I want to make sure we have enough time for the enforcement of settlement agreement, and we have 30 minutes. But I do have one question for you that I'd like you.
And may I, in addition to your question, make a statement regarding just one of the elements that was raised in reply to my motion?
Maybe, especially if it's the same one.
Yes, sir.
I misapprehended the nature of the mandamus claim. And so when you were sharing with me that there are other legal remedies such that we don't reach the extreme potential relief of a mandamus action, I was thinking that it related to getting the commissioner to do something about the fire station. And it's not. And I'm trying to figure out what declaratory judgment action someone could bring in connection with the alleged failure to comply with the state property commission policy, because it's not, this is what we think the policy means. It's, you're not doing it. You aren't, take a real simple example. If it is a building of value, all lighting should be in the off position. Let's assume should mean shall for purpose of this argument. If the lights are on, Commissioner, you have to go turn the lights off. And if she won't, wouldn't mandamus lie to get her to turn the lights off in the buildings of value per this policy to which I assume she's subject? Because that would be your first argument, would be she's not even subject to these because they apply to national parks or state parks and not the hospital.
Well, that is actually, that leads to exactly the answer that I was going to pose, which is the declaratory request would be, do they apply? Do the state property commission apply? And if so, again, as the court mentioned earlier, are these discretionary? Are these discretionary because are these buildings value and are they not?
I got the discretionary part and I have some pretty clear thoughts on that. But if we assume for my question that I find that they are not discretionary, because at least this part, you need to have the lights off on a building of value, and pretend building of value is anything that still has four walls. Right? That one still has four walls. Lights need to be off. Your response to that is, how do we know? First, there would need to be a declaration that DBHDD and thus the commissioner are subject to state properties commission policies. I have no idea about that because I've never heard of a state properties commission policy before I met you people.
I do think that would require a declaration. And more importantly, I think it would require, you know, when the courts make declarations against state agencies, the state agencies follow them. You know, especially in the case of the governor, for example, there's a clear delineation that one does not reach mandamus against the governor because the governor follows the law. And in this would be a similar case. All it would require would be a declaration making that statement. But in furtherance of a statement I wanted to make, I understood Mr. Palmer's excellent argument to include that mandamus is appropriate because the declaration won't provide the relief sought by the county. And the constitutional amendment provides for both declaratory relief and subsequent injunctive relief. I think that subsequent injunctive relief, if a declaration is made, certainly provides exactly the same remedy.
But as I understood it, it's not a challenge to the constitutionality of, no one's challenging, at least the county's not challenging the state properties commission policy. I don't know that you could challenge the constitutionality of that. They're saying, this exists, you, commissioner, have an obligation to enforce it, and you aren't. Just like head of pardons and paroles, you are required after 7 years to give someone a hearing, and you didn't. You don't have to give them parole, but you got to give them a hearing. And here, you need to turn the lights out on buildings with four walls, and you haven't done that. Making it up, but if it were that non-discretionary, isn't this the right action to bring?
Your Honor, I don't believe so, because you began your question with, is this constitutional? And that's the gist of what I understand the court's question to be. And the language of the constitutional provision provides, from acts of the state or state agency or officer, therefore outside the scope of lawful authority or in violation of the laws.
Okay.
Not in violation, not whether the laws are constitutional, but in violation of the law.
Got it. And so a way to cast it is Baldwin County is saying, Commissioner, you are violating the law. criminally, but the law as it would be enshrined in the State Properties Commission policy, because you're leaving the lights on with buildings with 4 walls. And your point is simply this provision, the constitutional amendment, says you don't get a jump straight to a mandamus. You first have to get a declaration from a judge in a superior court that in fact, this situation is a violation of policy here.
Because of the harshness and extraordinary remedy that is mandamus, yes, Your Honor, that's exactly what we're saying. Generally speaking, again, the liberal interpretation of the deck judgment action allows, that should be your first line, that should be the court's first line of defense, the first opportunity for an aggrieved person to receive their response.
And that would allow then the commissioner to decide, well, I better start turning the lights out before there's we don't even need to get to mandamus, because Judge, you've made clear that whatever I'm doing now is in violation of the policy that was identified by the petitioner, the aggrieved party wasn't being complied with. Okay.
State and state agencies follow the law. You make an order, sir. That's what we do.
That's the theory.
Yeah. There's one other real brief issue, and it was raised by Mr. Palmer. It has to do with additional briefing on the potential retroactivity and the application of the impairment clause. Your Honor, I raised that issue in response to plaintiff's reply to our motion to dismiss. I think it's something that was raised earlier, and that's why I addressed it. I think they had an opportunity to prepare and address it as well. To the extent the court feels additional briefings required on that particular issue investing, we'd like the opportunity to pursue it as well.
Okay, I'll think long and hard before I ask for any more paper from either side, but I appreciate you flagging.
Your Honor, just 30 seconds to address the last mandamus point.
Yes.
Okay. So a writ of mandamus, I think a key distinction is a writ of mandamus is where an official fails to act. It's not that they're doing something unconstitutionally. Let's assume for a second that an officer had a statutory duty to do something.
But let's take out of the conversation the Constitution. I imported that, and I shouldn't have, because the amendment is broader than that. One way the amendment is used now is for a party to say this law is unconstitutional. I'm very familiar with that use of it. That is one way to do it, but it is broader than that. And the liberal interpretation of it would be in exactly your situation, where you're not saying that your client is not saying that the commissioner has done something unconstitutional, but there's a legal obligation through this policy to do certain things. And you're saying they are very discreet, as in no discretion, turn the lights off. You got to do these things. But the way I'll need to think about it more, and I'll let you make your point. I just don't want, I imported constitutionality into it again. And that's another reason why I was struggling with this. Like, wow, the mandamus piece doesn't seem to have anything to do with your arguments about the fire station. And they don't. And so I'm regrounded, but on with your point.
So if an official is failing to act, there is no declaration. They're not acting. We can't get a declaration as to whether their action is lawful or not. What Mr. Legal's argument is basically we need a declaration that this law is valid before we can get a mandamus claim.
I hear his argument to be the commissioner needs a declaration that this policy applies to her and that she's not complying with it.
But that is implicit. This court has to make that finding and issue the writ of mandamus. By making us file a separate claim for DEC is just going to bog down the courts, and that's not what the constitutional amendment says.
Okay.
It provides an alternative waiver of sovereign immunity for an action that you can bring, but sovereign immunity is already waived for writs mandamus. So we don't need to file this separate DEC action just to get back to where we are now.
When you say that sovereign immunity is already waived for writs of mandamus, what's your basis for saying that?
I think we've cited to it, and it's well established. The sovereign immunity does not apply to claims for writs mandamus. I think we've cited to it in our brief, but I could look on Westlaw on my phone.
No. You don't need to look on your phone. I just was curious if you think there's a separate constitutional provision or just the common law, the case law has developed. It sort of makes sense. I mean, how would you ever get a writ of mandamus otherwise? Because a person would say, I'm a state actor. You can't sue me unless. But
I believe it is common law.
Okay. We'll work through it. All right. So we have about 20 minutes left before I have to get on a a Zoom. I could probably delay that a little bit. It's a scheduling teleconference. Isn't that the 3 o'clock or is that? Oh, no, I can't delay that. Okay. I want to make sure we give full voice to the concern about the settlement. So if you feel like we don't get all the way through it, we can schedule a part 2. My thought was if we could start with, not to guide your presentation, there must have been some final email or something from the state that you felt constituted acceptance. And I guess that's where I'd want to start.
Yeah.
If that's one of the tabs.
Yes, Your Honor. So let me give you
A different binder. It's all right.
We're in 2 different places.
Thank you.
Hey, let me present that to Your Honor. This is, I'm going to sort of jump right into it. You'll find under tab 4, and Mr. Legal and I have already talked about it. You'll find in tab 4 the highlighted, and I'm using it for demonstrative evidence, exhibit A and B. These accurately reflect the language from the 2 emails. Mr. Legal has a copy of those emails and will presume file them with the court as the best evidence. I'm not using that for that purpose. I'm using this for demonstrative purposes. Included in that tab is also my affidavit, which is evidence of the communications between the parties and has not been objected to by opposing counsel.
Okay, before we go any further though, Mr. Legal did stand up. Do you have an issue with me considering A and B to tab 4?
Only to the extent, Your Honor, I don't have an issue with you considering them as demonstrative evidence. And to be perfectly clear, tab A and tab B represent the same emails that Mr. Welch and I have exchanged and talked about.
Yeah.
It's just our emails did not contain highlights.
Okay,
And
got it. And he said he highlighted
Right.
the blue and the green are additions from Mr. Welch.
Right. And to the extent that the court's able, and I have every confidence that the court is able to, put that to the side and look at just the language of the emails. We don't
Yep.
object to the emails themselves, but to the extent that that is not the best evidence because the plain unhighlighted emails would be, we would object and we would ask that the court review the document that Mr. Welch just provided you, which is the same document without the highlights.
Got it.
All right. Thank you, sir.
And Your Honor, also be aware, please, that the exhibit A that is attached that's included in tab 4 was attached to our motion to compel settlement on behalf of Baldwin County, does contain emails in communications with Mr. Legal on behalf of him representing the department. I did highlight things to make a point to him as to what I understood the.
All right, let's not get hung up on the highlights though.
All right, so what we're doing, let me jump right into this. The arguments that are raised in defense, because the briefing is there. We've asserted why we think we have a right to a settlement agreement, why one formed, and why we should be enforced in our brief. Let me jump to the points here. This whole case is about abandonment. This is about abandonment and neglect to the Central State Hospital, to the Baldwin County citizens. It is actually an abandonment of mental health over the decades. We have now an abandonment of a fire department that provides fire services to both inside the hospital and outside the hospital to citizens. This is now, we're talking about today, an abandonment of a settlement agreement.
It's a lot of abandonment.
I'm suffering from it. It's a psychological issue for me now. But when we're talking about this, what I want you to do, there's 2 real arguments that the department has made in response to our motion. The first is, and both of these are analogous to my mind to the emperor's clothes. They think that they provide cover, but everybody can see right through them. For example, the first argument is that an email is not a writing. And so therefore you can't consider the emails, even though you're holding them in your hands. Secondly, the argument is that they're not signed and therefore they don't constitute a contract by which it can be binding against the state and therefore constitute a waiver of sovereign immunity. So let me address those very quickly. To think about this is to say an email is not a writing.
You don't need to spend a lot of time on that. I'm more focused on whether there was an actual offer and acceptance when there's language like, well, we'll need to finalize the settlement. I think the parties will have, these are all from Mr. This is Exhibit A. Other details to work out, which are important, but not deal breakers.
Okay.
So
let me
that
address
kind of language, we're done. There's nothing to enforce here.
Oh, but absolutely. Case law is exactly the opposite.
The opposite. Okay.
Yes. So if you'll look at, and I'll refer you to tab, in our case, we cited to Johnson v. DeKalb County. Now, we're not getting to the sovereign immunity issue because I do want to address that with you, but to go directly to your points, in Johnson v. DeKalb County, that case also dealt with attorneys exchanging emails in a settlement discussion. There was a concept plan that wasn't hammered out. Court still found and upheld a form of a settlement agreement, the monetary amount, dismissal of the claims with the approval of a concept plan. Concept plan wasn't hammered out. There was disputes as to what was supposed to be in that concept plan. Still, the courts upheld the settlement agreement because the courts are looking for compromise. They're looking for things to settle so as to clear the docket and create judicial efficiencies.
I'm all for that.
All right. Then the Pereza case, which is 273 Georgia App 880. It's under tab 5 of your notebook. That case also dealt with a question that I think you're raising about, I had expressed in my response. So the email from the department was, here are the terms from DBHDD. This is our final and best offer. $7.2 million in exchange for you dismissing the case and terminating the contract. The rest of that is all precatory language, is all logistical language, and it is all language dealing with things that are post-dismissal. Aspirational things we'd like to see happen, but expressly stated by me that they are not binding. In fact, it's stated by opposing counsel that they were not to be deal breakers. And in fact, we were reciprocated in saying that it should not be bars to settlement. But if you look at that case, Your Honor, you'll see there that in that case, the responsive letter by the attorney in that case said that that I believe this letter sufficiently memorializes our agreement, but if you believe other documents need to be executed, let me know. That's from this case on page 881. And the court said, yes, we looked at that. The let me know language is not dissimilar from the language in the email that you have from me up there.
So let me ask another question then. I'm following on all this. If I look at A and B together, A, Mr. Legel says 7.2 million, you dismiss. That's on May 5. 4 days pass, you write back, Board of Commissioners met, and here is our counter offer. My words, not yours, but here is our counter offer. Give me a call if you have any questions. If, now I quote directly, if these general terms are acceptable to DBHDD, if you like our counter offer, let me know.
I'm sorry, Your Honor, but I don't use the word counter offer in there at all.
No, I am calling it a counter offer because I see it as a counter offer. The word counter offer is not in there. But you list all these things that flowed from the Board of Commissioners meeting, and then your words, if these general terms, my bracket of the counter offer, are acceptable to DBHDD, I presume your client will want you to draft blah, blah, blah to consummate the settlement. So it's a done deal. It's, hey, if this works for you, DBHDD, let us know. How am I misreading your response to Mr. Legel's offer?
That's easy, Your Honor, because if you follow his offer, it's very clear as to what we're talking about in these other terms. So if you'll look there at the May 5th email, there's the clear offer of $7.2 million, dismiss and terminate the agreement. And then there is this discussion about this terms of settlement. And his statement is, I think the parties will have other details to work out, which I believe are important, but not deal breakers. We're responding to that statement specifically with our responses. And then he gives an example of things that he wants to cover. Well, that's all pertaining to the settlement agreement that is to be drafted later. That is not pertaining to the terms of settlement. And our response is very clear in that respect. I'm sorry, Your Honor. It says that the county will dismiss with prejudice all claims. In exchange, the county will accept $7.2 million, no strings attached.
But we need to get the money first before we dismiss and before the contract is deemed terminated.
But if you look at the language of these cases that I've cited, Your Honor, you'll see that those terms, the courts have always looked at those terms as the finalization of the actual terms of a settlement agreement. It is routinely the case. A release, for example, a release from in a negligence case there's always a release accompanying them. The courts have construed that as not being a counteroffer. That is merely just terms of consummating what the parties intend to do, which is to dismiss and finalize the case. Your Honor, everything after you're seeing there in blue on this Exhibit B is me going through and responding to all the aspirational language that DBHDD put to us. We didn't offer these things as solutions. We didn't offer these things as anything but a response to questions asked by opposing counsel and DBHDD. This is as clear and plain of a settlement agreement that can be entered into. On the issue of signatures, Your Honor, it is clear from the case law that OCGA 15-19-5 expressly authorizes attorneys to bind their clients. This has been affirmed by the Supreme Court in Brumbelow versus North Propane Gas, 251 Georgia, 674, wherein the court actually analyzed whether a signature was required to create a binding settlement agreement under that code section.
Is it different when we deal, I'm sorry to interrupt, when we're dealing with the government? I'm not troubled by this argument. I get this all the time with lawyers where, hey, we settled, and they show me the email chain. And they did, because lawyer X with her signature line, and it's not a Jane Hancock, it's just his Jane Doe lawyer,
right,
said, yes, we accept. Done. And that's enforceable. There was recently some poor assistant attorney general got pounded on by the Supreme Court over this death penalty. When are we going to execute people? And there was this agreement. Was there agreement? And well, I didn't really have the authority. Is it different when we're dealing with the state? And so Mr. Legel is very authoritative. He's not the governor. He's not the commissioner. And so he could tell you we're good to go. He is counsel for the state, but somehow counsel for the state when it had to do with a moratorium on the death penalty wasn't counsel for the state. And that displeased the Supreme Court, but a person did not change his or her mind despite the verbal beatdown.
Yes, and in anticipation of this, what I thought would be a discussion today, there is a case that speaks to that question. It's the city of Atlanta versus Black, and I'm in full candor to the court. I want the court to be aware of it. It's 265 Georgia 425. And in that case, there was a municipal ordinance that said the city's attorney didn't have the authority to settle cases in excess of $500. There's a law.
Okay.
And what is clear, there's not a law in this case the state has not pointed to, but let me point to you, for example, that the state attorney general in its own opinion from 1984, it's opinion number 84-48, July 27th, 1984, says the responsibilities of the attorney general as the legal advisor of the executive department, including giving legal advice and representing executive department agencies and officers in court as being their authority. In legal matters and matters of legal representation, the attorney general went on to say, both in and out of court, the independent authority of the attorney general is implicated. Independent authority has to have it. He has to have the decision to be able to make these decisions independent of the executive branch. That legal and it goes on to say the legal representation of each executive branch agency by the attorney general not only fulfills this state's historical constitutional mandate, but also allows the executive branches to speak with a single voice on legal matters to avoid inconsistency, which appears at times to befall other states. Unless the state can point to a prohibition on his power, his asserted power is I'm independent, I have a duty to represent these executive agencies, and if that is true, then he also can bind those agencies unless there's some other authority that they point to and notify us in advance of. Otherwise, how would we know? And that is the material distinction between what you're concerned about and the case law.
Okay. Got it. I have two emails, A and B from you, and then the unhighlighted ones. You're a popular guy today. Was there a response from Mr. Legel or anyone else from the state to your May 9th email?
Yes. So what happened, you'll see in the entire collection of the emails is attached to the affidavit, Your Honor, which is in the record already, but you have it for your review. You'll see that there's a discussion that goes on in which he responds to specifically I followed up with him and asked him if we had heard anything, because we were the assumption on our part was actually not an assumption, it was clear. We will work out a settlement agreement. We must work out a settlement agreement by June 30th to dismiss this. We're fine with that. The terms are not deal breakers. Here are some things that, Mr. Legal, I want to talk to you about us doing. One of which was to include a plan for securing, abating, and demolishing buildings, to the very point we're making as to our firefighters or the city's firefighters or anyone else that might have to go in those buildings. That was laid out in those emails. And the response, I checked on them and I said, hey, where do we stand with this? Time is the essence. Where do we stand with this? And the response is, thanks for your place. I don't have any information for my clients, but I'll ask you and let you know if something else comes up. I further responded back, again, checking on it. And then it became this twist. No, we never made you that offer. No, we didn't make an offer. You made an offer. And now we get into semantics. And Your Honor, the simple truth of the matter is that this has been a contractual relationship for the benefit of the citizens to protect those buildings and the people that would occupy them. And please bear in mind, we're not only talking about buildings that are abandoned, dilapidated, roofs caving in, open elevator shafts, etc. We're still talking about the Veterans Hospital that's there that does have occupants. We're talking about other mental health facilities and offices that are there and prisons that are there that all have occupants. They need to be protected. And the bottom line on this was that there was a contract for that protection for 50 years, and they walked away with it in violation of the termination provision of that clause of that contract. This settlement resolves the issues that Baldwin County has. And furthermore, the proposal by DBHDD to actually mitigate the problems there also accomplishes the goals that we think are important to the public. We ask that you enforce that settlement agreement and let this case go by this wayside so that we can actually move on to taking care of the business and spend the $5 million we're talking about on the abatements.
Got it. Thank you. Can you let the Williams people know we'll be a little late? They said it would only be 15, I think. I don't believe them, but just tell them to log in and sit tight.
Your Honor, I'll try to be quick. I know the court's busy.
It's all right. We're buying some time on the next thing. So
I'll still brevity is the spice, as it were.
all right.
Mr. Welch brought his narrative to the front with this is an abandonment of various things. Let me give the court an alternative narrative. This is not one, but two attempts to manufacture contracts that don't exist. It's an equally valid narrative, and it's the one that the state thinks is far more important. We think it's far more demonstrable in this case than even in the prior case, but certainly far more demonstrable.
Because there was a contract in the other case.
There was a written contract at one point, and the other one, in this case, we have emails. And I'd like to, first of all, give the court the opportunity and ask the court to review them all closely. Read them all. I think at that point, we're probably done. But that said, I'd like to go over them.
So they're emails pre-May 5. I know there are emails post-May 9 because I heard about those. And you're saying
there are no emails pre-May 5.
Oh, that's where it starts.
Yes, sir.
You start it with your May 5 email and then follow it down the road.
It's not my obligation to put the contract into the record, Your Honor, but that is what's in the record.
Okay.
And on May 5, it begins. And then on May 9th, there's a response. And then on May 16th, there's a request for a response from me. And then on May 30th, there's another request for a response from me. And I'll get into those and explain them a little more. But those additional requests for response should probably demonstrate that we don't have a meeting of the minds. And I'm going to address sovereign immunity really quickly. I know the court has an opinion on it, but I want to raise it because sovereign immunity is only waived for express written contracts that contain all the necessary terms. There are a number of cases that have looked at things like emails and have never found, and nothing within the state of Georgia has ever found that emails represent contracts. No RTT the RTT and Associates, which we cite in our brief, contained emails. That wasn't a binding contract to waive sovereign immunity.
So your point is more refined than the one I was making. People can form contracts via email left and right. The state forming a contract via email, that's where sovereign immunity comes in.
Yes, sir. That's exactly what it says.
Okay.
There's a quote from the RTT case that says general rules of contract law that might otherwise support a claim for breach of contract or for damages between private parties will not support a claim against the state or one of its agencies if the contract is not in writing as to trigger the waiver of sovereign immunity. The standard against the state is simply higher. And that's from Department of Labor versus RT2. I also want to briefly address the court's, actually Baldwin County's case of Johnson versus DeKalb County. That case, again, didn't involve sovereign immunity. Mr. Welch acknowledged that, but the emails in that case were significantly different than the emails here. And comparing apples to oranges is something that this court doesn't have to do when it can look directly at the emails. With that in mind, I want to look at the actual elements of a contract. And the first is, of course, things like mutual assent. The second is a meeting of the minds. The emails don't represent this sort of mutual assent or meeting of the minds that's required to form a contract. The alleged offer that I wrote referenced an amount, and I freely admit, it referenced an amount of $7.2 million that to settle the claims, but it also raised questions of who would provide fire services after the termination of the contract. I also raised the issue of whether Baldwin County would continue to occupy the fire station for some period of time afterwards. And finally, I said that DBHDD intends to demolish, remediate, and secure the buildings, but it'll take time. And we need to work out the details of that because nobody wants another mandamus claim while we're in the midst of working on that process. Baldwin County responded on May 9th. And just looking at the words of Mr. Welch's email, it's a response, Your Honor. It's not a, nowhere in it does it say, I accept. It's a response. And it contained a number of bullet points, 5 in fact. It was nearly a page long. It added elements, it added terms that were not addressed in my email. Those terms included things like they wanted to keep the amount of the settlement confidential for as long as possible. Another one, it said payment would need to be provided before dismissal of the contract. Neither one of those are addressed in my earlier email. The third one, and the court referenced this one, it described the city and the county's service delivery schedule and automatic aid agreement, but it also, and I'm going to quote from the email, requested that DBHDD publicly provide within a reasonable time of dismissal its commitment and plans to secure the buildings at CSH and its plans, if any, to demolish and or remediate CSH buildings, end quote. Your Honor, I would assert that each one of those three things are not a clear and unequivocal demonstration of acceptance. They are, in fact, terms of a counter offer. And in particular, I also want to add for the chronology of this case. Again, Mr. Welch responded on May 16th with another response asking, I'm sorry, the email speaks for itself, but Mr. Welch wrote asking for a response to his email from us on May 16th. He wrote again asking for DBHDD's response on May 30th. And in that, he actually volunteered, and again, I'm going to quote, he is beginning to become concerned with DBHDD's intentions in these settlement discussions, end quote. He then requested a response this week from DBHDD regarding terms of settlement and corresponding preparations of the settlement document if settlement is to be had. Your Honor, I would assert that
The date of that email?
that email is dated May 30th. And I would assert that that does not demonstrate a meeting of the minds as to settlement. Now, applying the law to this particular set of facts, I'd like to do so with a quote from the Georgia Supreme Court from McReynolds versus Krebs. And I quote, "To constitute a contract, an offer must be accepted unequivocally and without variance of any sort. A purported acceptance of a party's settlement offer which imposes conditions will be construed as a counteroffer to the offer to settle." That's both the Georgia Supreme Court's quote and the generally accepted practice. If you add things to a settlement offer, it's a new offer. Another quote is the Supreme Court, or I'm sorry, this is the Court of Appeals in Powerhouse Customs. And we cite both these in our briefs. "An answer to an offer will not amount to an acceptance so as to result in a contract unless it is unconditional and identical to the terms of the offer. To constitute a contract, the offer must be accepted unequivocally and without variance of any sort." Mr. Welch's May 9th email is not an unequivocal acceptance. In fact, it doesn't say acceptance. It contains a bunch of different terms and a bunch of different requests. It's a counteroffer. Finally, I want to add one somewhat technical argument, and it has to do with the ability of governments to enter into contracts, and particularly counties to enter into contracts. Counties can only enter into contracts through the affirmative acts of their legislature, of their board of commissioners. It has to be voted on by the board, signed by the chairman of the board under normal circumstances. Mr. Welch, in his email of May 9th, talked about the board having met in executive session. If the board met in executive session and accepted an offer such to make a contract, they would have to do that in public, in a quorum, and spread that on the minutes. And there's no evidence in the record, and there's no evidence on the Baldwin County website to indicate that that was done. Finally, I want to just address the terms in a little more general sense and why this isn't a contract, because those terms are too vague to be a plain and enforceable contract. The emails, frankly, raise more questions than answers. I raised a question about the provision of services post-settlement, namely who would provide services, whether it would be the city or the county. Because CSH is within the city, the law says that it should be the city's responsibility to provide fire services. There was a question of whether Baldwin County would continue to occupy the fire station for some time for the benefit of the non-municipalized area. That was never addressed by Mr. Welch. We don't have an answer to that to this day. Finally, there were questions about negotiating remediation of the CSH property. And we don't have we needed a clear-cut plan, something like the settlement or the concept plan that's in the DeKalb County case. Now, the concept plan in the DeKalb County case was actually written down. They disagreed with components of it, but it was written down. There's none of that. In fact, that's it. That's even affirmed by Mr. Welch's response email, in which he wants a public statement regarding our remediation efforts. The Court of Appeals, again, just to test the enforceability of a contract with vague terms, has quoted, "The test of an enforceable contract is whether the language is sufficient to plainly and explicitly convey the agreement between the parties. A promise must be sufficiently defined as to both time and subject matter to be acceptable." This email doesn't have time or subject matter to many of these terms to be acceptable. Frankly, my email and Mr. Welch's response raised more issues than they put them to bed. It's not a plain and explicit demonstration of the meeting of the minds. The follow-up emails demonstrate that. One of the terms, continuing occupancy, was never addressed by Baldwin County. And then 3 other terms, confidentiality, timing of payments, and the public plan for remediation, were raised in the response and never accepted by DBHDD.
What is your response? And maybe you've responded by saying it's a higher standard for state contracts. This doesn't have to do with whether it's email or not email, but the point that Mr. Welch made that there's case law that not every I has to be dotted and T crossed. If there's agreement on the central piece, which he is characterizing as 7.2 million, and a dismissal, then the other aspects are ancillary. Like, was there going to be a release or not? Is the timing before is the payment made before dismissal or within 2 weeks of dismissal? Those are not unimportant, but not central. And so courts ought to require the parties to adhere to their central agreement and let them figure out the rest.
Your Honor, I would argue that
it's contrary to Krebs.
It is, and it's also not appropriate in this particular case, I believe, because of the variety of claims brought. For instance, the mandamus claim, the ongoing response, the ongoing allegation that DBHDD has to maintain the landscaping, for instance. That's not something that was addressed at all, but it's certainly not something that can be addressed by a large check. That is one term. $7.2 million is nothing to scoff at. The state takes its financial responsibilities very seriously in situations like this. But this particular case has a lot of other components. It has components such as the protection of Baldwin County citizens through some kind of station for their fire department. It has who's going to provide fire coverage for 2,000 plus acres in Middle Georgia that has been managed by Baldwin County, but legally is probably required to be managed by another entity. All of these are not technical elements such as dates and times. These are important. These are material elements. These are material elements that need to be expressed unequivocally, clearly, plainly, and explicitly. And because they're not in that, this isn't a settlement agreement.
Okay. Thank you.
Thank you very much.
Mr. Welch, final minute.
Your Honor, look at the emails. I think that they are very clear. They do set timeframes. They actually do speak to the mandamus claims. The emails are to me, are perfectly a settlement agreement and enforceable. And the case law supports that. I want to raise a few issues. The RTT Associates case that's mentioned does not speak of emails whatsoever. That case has said nothing to do with whether an email constitutes a waiver of sovereign immunity. Please read the case. The other case is cited to data inquiry actually says that there could be a holding of a waiver of sovereign immunity when there's a signed contract or there are documents that are written that when in concurrence are all signed and manifest the intent of the parties. That case does not hold that emails can't be sufficient to waive sovereign immunity. Also, I will just point out the Winter case that was briefed by opposing counsel. Understand that also dealt with the delay. There was a 9-week delay between the emails that were put together. In this case was 4 days. There's no delay. And as far as the settlement by the Board of Commissioners, they are authorized to settle cases in executive session. Obviously, the final agreement would have to be voted on in a public session, but for purposes of settlement, you are perfectly allowed and it's perfectly legal to have those discussions in executive session so as to convey them to opposing counsel in the deliberations. Thank you, Your Honor.
That last point you made, that's just something you know because you represent counties, or that's unique to Baldwin, that they can agree to settle something on behalf of the county in executive session.
Yes, and including doing it mediations as well. The ultimate final of approval of that would have to be done in public session. We concede that point. But in this case, what was the meeting of the minds? Did they form an agreement at that time? And the answer is yes. And they had that express authority from the Board of Commissioners at that point, which is to say that had a settlement agreement been drafted by DBHDD as it said it would, before the 30th of June, the deadline it created, then we would have had an approval because those terms are there. And the other terms, as he said in his email, were not deal breakers. And they were all just terms that were supposed to be incorporated in a settlement agreement DBHDD committed to drafting.
All right.
Your Honor, may I give these Exhibit A and B to the court reporter just for?
You may. All right. That is it for today. I appreciate everyone's preparation. I will let you know if I need more input on the executory versus executed contract and the piece that you were claiming, Mr. Palmer, was sort of new to you. Mr. Legel has said it wasn't so new. If I feel like I'm fuzzy on it, I will certainly let everyone know and there can be more briefing, but I feel well briefed. And so for now, I'm going to say let's hold off on that. I will take this under advisement. If we hit, as Ms. Niles and I are talking about this, some area where we think we benefit from just a letter brief from both sides, and it will always be from both sides, even though it may be, Mr. Lego, I didn't understand X. Both sides will get to say, well, here's what you need to understand. Otherwise, we'll get to work on this and let you know if we need any other input from either of the sides. Anything else, Mr. Welch, on behalf of your client?
Your Honor, thank you for the afternoon.
You're welcome for the afternoon. Anything else, Mr. Lego, on behalf of your office? It's okay to say no.
Thank you, sir. For the sake of candor to the court and clarity, I would just to make sure that we're all on the same page. The emails that are in question, the May 5th and the May 9th email, Mr. Welch produced the highlighted copies as demonstrative evidence. I don't think, and I don't know, I could be wrong, I may have missed something, that the actual emails were ever submitted.
They're not attached. I thought someone said they're.
Yes, they actually filed a record as affidavit on with our motion to enforce a settlement.
There we go.
Okay, all right. If the court's comfortable with that, I just wanted to make sure that I don't want to win on a technicality of not having the contract in there, Your Honor.
Yep.
I want to have that. So I'm glad it's it. That's all I had.
Great. All right. Thank you, everyone. Safe travels. Have a good weekend. And please take care of the court reporter. more binders. Will you let the John Peak people know, maybe a couple minutes late to that case? That's the 3:30. I'll go get on with Williams.
Nice to meet you.
I was the attorney that beat up for the Supreme Court, so. You know,
I've been there.
there's nothing you can do.
I'm used to it. I'm used to it.
Yeah, luckily, all this is no little bit, McMillan's project.
So she's taking my.
Yeah, she definitely hammered me.
Brandon,
Yes, sir.
just can you confirm that the court reporter allowed roll out to split takedown?
Oh, yeah.
No, it's still fresh on my mind, it's all the wounds. I was the attorney hammered by the police.
Oh my gosh, that explains. All right, sorry, I didn't PTSD moment for you.
Exactly.
Huh. I wouldn't have brought it up if I had known.
Yeah, it's
It just
fine.
seemed kind of
It's
relevant.
a couple weeks behind now.
The wounds, the physical wounds have begun to heal.
Exactly.
All right. That explains you got really small in your chair when I was talking about it. Whoa, what's that reaction?
Thank you, everybody, for your time.
I gave away most of my head stuff. It's like I didn't get this.
Thanks, sir. And have a good weekend.
Yeah, who's on? So.
What's he changed?
Yeah.
Okay. Well, we're gonna have it, right?
We're good here,
Okay.
yeah, we're done.
Alright. Okay.
You too.